good afternoon, everyone. I'm just delighted that we're all together again. I look forward to meeting our newcomers and to reconnecting with HEPNET members. Uh, I've had the pleasure of meeting in the past. There was a tremendous amount of law to cover today, and after a brief introduction, I'll take you through judicial developments and then legislative developments, and finally some really important, but they're last, executive agency regulatory type developments. So let me get my clicker going here and see. All right, we got this is only a test. If this were an actual presentation, I'm not getting clicking action, so I will. Ah, very good. Thank you, Pranisha. She's a pro. I'm an amateur. At HEPNET, we do financial disclosures. I provide fee-based services for colleges and universities around the country, and I work entirely pro bono for HEPNET. I'm currently HEPNET's general counsel, having served as the founding board chair and then a board member, and now I'm relegated to the legal role, which I'm very happy to take on. So by way of introduction, there's just been a lot of discussion of child abuse, child protection in the news over the last year. On the far side of this slide, you see a shot from the opening opera of the Metropolitan Opera season this year, based on the autobiography of Charles Blow called Fire Shut Up in My Bones. And not only was Pranisha present at the opening night of the Met in New York, but I'm sure it was the first time that a story of child abuse was told on the Metropolitan Opera stage. It was also the first time with essentially an all-black cast and a black composer for the work. So to me, this illustrates how much this issue is now in culture, and we're more ready to discuss it as a society. And as I mentioned, it's based on an autobiography by a current journalist. We also had the Southern Baptist Registry disclosure. Yet another religious convention has revealed its history of abuse, including situations of child abuse. So we have names of people serving as youth pastors and students at Southern Baptist universities and professors now publicly disclosed for the first time. And then we also had the Pope going to Canada to apologize to Canadians, and particularly the First Nations, for the horrific crimes in the First Nations residential schools, where many children were abused, neglected, and the deaths of hundreds of children are now coming to light. So I think as a society, we're looking more at, oops, that goes the wrong way. Child abuse. We've also had at least 3 high-profile convictions this year. On the far side, you'll see R. Kelly, who was sentenced to 30 years. In the middle, we have Ghislaine Maxwell. R. Kelly is a popular singer. Ghislaine Maxwell was a Confederate of Jeffrey Epstein. She was sentenced to 20 years for essentially procuring underage girls for his sexual satisfaction. And then closest to me, we have, there was a documentary series on Netflix called Cheer. And Jerry Harris was a popular cheerleader on this very competitive team. And in the 3rd season, his abuse of two younger boys who were brothers in this cheer team came to light. There's a tremendous episode in, if you have Netflix, in that cheer series where the mother and the boys talk about the struggles with disclosure that they faced. So I really commend that to your attention. So I just found more this year in terms of the abuse of children, the protection of children, these high-profile crimes. So with that having been said, I'll get this right here in a minute, I'd like to turn to judicial developments. I will be covering child pornography and child abuse in both state and federal courts. I'll be talking about convictions and arrests, with the caveat that someone who's arrested is not yet presumed innocent until proven otherwise. So we have some sentences for child pornography. I think the lightest sentence I found was a professor of history from Chico State who was sentenced to 2 years of probation. If he violates probation, then he will go to prison. And he was actually watching child porn while the agents were executing an arrest warrant for him. He did, however, admit to a sexual addiction, and I think those factors, his personal remorse, contributed to this very light sentence that he received. We also have here Professor Daniel Deocampo from Georgia State University, a geosciences professor, and he was accessing child pornography on the university network, both in his office and at home. He received, as you can see, a prison sentence of slightly over 4 years, 10 years of supervised probation, and a $10,000 fine. These fines are typically imposed when there are identifiable victims in the child pornography, and so the fines can become restitution for identified victims. I'm not certain that was the case for Professor Del Campo, but I simply mention that as a common judicial element of sentencing. Now I'm moving from child pornography convictions into sentences for child abuse. You see a math professor at South Texas College who was sentenced to life. He had abused some young boys over a long period of time. His former student was also involved in this. I'm not sure if she made her own children available, but she is serving a sentence of 15 years. We have a professor from Bowling Green State University who was sentenced to 25 years for rape of a child who was under 10 years old. And you can see that these crimes don't necessarily involve the universities. And I think that's an important point because abuse happens statistically more often in the community, within the family, than in camp settings or youth serving programs. But we will get into some where there were students, younger students of professors. We also have a professor from the Rochester Institute of Technology and Film Studies. He was sentenced to 15 years. He was sex trafficking a 15-year-old and also, I believe, the sister of the 15-year-old. And the older sister came forward. He was charged with these crimes, and his victim actually died of a heroin overdose. He was not implicated in providing heroin to this girl, but he was trafficking her. So it goes on campuses, it goes on outside of campuses. There are ways to alert university public safety staff to signs of sex trafficking. Sometimes it's just a car they stop that's driving through campus. It may not even be people affiliated with the university, but they're signs that public safety people can learn um, of why do you have so many condoms in your car? I want to take this young woman or young man aside and interview them separately from you. So there are signs and techniques of sex trafficking, and here we have a professor who was engaged in exactly that. Here's another sentencing for abuse, and this is quite an odd story. Franklin College is a small private institution here in Indiana, and Thomas Minar was president of Franklin College. I believe he was visiting his elderly mother in Wisconsin when he was arrested for abusing I believe it was underage boys. And interestingly, at his sentencing, both President Minar, his defense lawyer, and his husband made reference to his very stressful job, and the faculty think they run the institution, and the governing board think they run the institution, and I was caught in the middle. And the judge replied, the judge was not persuaded by that and said, a lot of people have stressful jobs. A lot of people are college presidents, but they don't resort to abusing children. So take that excuse and put it where the sun don't shine, if I can be a little crude myself. So he was sentenced to 6 years in prison, which to my mind is a relatively light sentence, and 6 years of supervised probation. Again, if you violate the terms of your probation, you're slapped back in jail for a much longer time. Here's another professor who was sentenced for abuse. Emerson College, a performing arts professor. He was sentenced to 30 years. He previously had been a middle school teacher in Minnesota and continued one relationship with an underage youth while he was in Massachusetts. So he will be put away for a very long time. This is an interesting case that was really brought forward by the student newspaper at the University of Michigan. There was this violin professor, Stephen Ships, who had taught at other institutions in Nebraska and North Carolina. I think he was quite a well-regarded violin instructor, and I know that Michigan has a really strong string program. I play the cello. I know people who've studied music there. And he transported a 16-year-old from Michigan to New York for the purpose of sex, and did have sex with her. And one of his students was saying, I never knew at a lesson when I had an appointment with him whether I was going to have a violin lesson or whether he was going to initiate sex. So yes, he was sentenced to 5 years. Now coming up, we have the longest sentence that was imposed in 2022. This is a former banking executive named Michael Pepe, who was in the banking field, a manager, high-level executive, who retired to Cambodia and had apparently a beautiful villa in the nicest part of Phnom Penh, and was sequentially abusing many young Cambodian girls. So he happened to be a professor. I don't believe he was abusing any of his students. So why was he convicted in California and sentenced in California? There's a federal law that prohibits what's sometimes called sexual tourism, traveling to another country for the purpose of engaging in sexual activity that would be illegal in the United States. So he traveled back and forth. He had a home base in California, but really, I think, was spending more of his time in Cambodia, which is I think, a known destination for sexual tourism, as is Thailand and some other countries. So he traveled back to California, and there became a legal question of, was he traveling back and forth for the purpose of these sex crimes? So that went up on appeal, and the federal authorities brought to the United States some of his survivors. They testified not in English, and it turned out their interpreter was in a relationship with an immigrations and customs official. And so the prosecutors disclosed that, and they had to sort of sort that out. He had a second trial. He appealed on this question of, was I traveling for the purpose of having sex? And the answer was yes. So he wins the prize this year with a sentence of 210 years, much longer than a life sentence. So we have lots of perpetrators who were sentenced. And then I try to keep this presentation fresh and current. This professor pleaded guilty yesterday. She hasn't been sentenced yet. That's not coming till the first week in October. She taught biology at a community college in Alabama. And just yesterday, I think she was charged with 20 counts of crimes. And so she pleaded guilty to lesser charges, to 8 counts of sodomy, 2 counts of second-degree sex abuse, and traveled to meet a child for a sex act. As with many of the other perpetrators, she's married, has 2 children, and her plea deal with the prosecutor calls for no more than 15 years. The sentencing, I believe, is October the 6th, and the judge will take that as a recommendation, but is not bound by that plea deal that Professor Sonnenstein entered into. All right, so I believe we're going next to the arrests. And again, these are people who are innocent until proven guilty, and I'll just go very quickly through these. First up is Scott Shaw, who was the director of sports medicine and athletic training at San Jose State University. And he is charged with abusing female student athletes. I've not actually heard or checked or learned, I've checked, I haven't found an answer to whether any of his victims were underage, but that has been the case with other people in the healthcare field in a university setting, trainers, physicians, Larry Nassar, and so forth. We have a growing number of perpetrators who've worked in student health, athletic training. And so I think it's a fair assumption that some of his victims may have been underage, but I don't know that for a fact. And then next we have John Reyna, who was a public safety officer at Southeast Missouri State University. He had worked for a nearby police department and was under investigation for certain improprieties. He resigned and he was hired by the university. They had no knowledge of his recent history, and he has been charged with abuse of a minor. And I just did a little my own CSI, detective work, and he is wearing a T-shirt for a local high school in his mugshot, and that just seems a little strange to me. So he was perhaps one of these people who was seeking out opportunities to be with underage um, uh, people, with teens, kids. And then we also have a student, I haven't included his name, at the University of Evansville, who was tutoring at a local elementary school. How many of you have college students who are tutoring at a local elementary school? I bet virtually everybody in the room. And he has been accused of surreptitiously taking photographs in a elementary school restroom. So again, charged, not tried, or many people in this situation will plead guilty to lesser charges, as Professor Sonnenstein did yesterday. We've also had some sting operations, and most of these are run by the FBI Project Safe Childhood, but they can be run by other people. And so we have two professors who have been charged with soliciting sex from someone they thought or knew to be underage when it was really a law enforcement person on a chat room impersonating an underage person. And so in these sting operations, the law enforcement tries to make clear to the perp or alleged perp that, I'm only 15 years old, just to confirm that they're seeking sex from someone who is underage. And then in our second situation, Chaffey College in California, we have a technician in the performing arts. And there's been at least one and maybe more of these groups that do private sting operations. And so they post their own messages in these predatory chat rooms and live streamed this. So they set up a meeting, hi, I'm a 13-year-old boy or girl. I'll meet you in the parking lot at the grocery store, or here's my home address. I think more often it's in a private place like a home address. And then they lure in the perp and confront the perp. Usually it's a he, usually it's male. And in this case, they live streamed. In other cases, they will film and confront the person. What were you, why were you coming here? When it seemed the occasion was to have sex with a 13-year-old, 12-year-old, 10-year-old, whatever it might be. I gather that this live stream video is no longer online unless you go through the Wayback Machine for archival material on the web. So again, we have law enforcement sting operations, and then we have less often these local, I want to say vigilante, but that's a little too strong, local groups that are seeking to flush out child perpetrators and trap them. And in this case, that did lead to an arrest. And now moving into some arrests for child porn. We have a professor of veterinary science at Auburn. We have a director of creative writing from St. Leo University in Florida. Again, only arrests. We also have the chair of philosophy from Butler University, also here in Indiana. In the articles about his arrest, there were quotes from a student who had taken an ethics class with him and had gone to his office hours, and his arrest totally freaked her out. I was in his office with him. And even more so, in my ethics class, he taught us, if you do bad things, are you a bad person? That became a topic for philosophy discussion. So, I think even with there can be, with child pornography, there are most importantly, I should say, the child victims who are portrayed in the pornography, and then this student's reaction illustrates the larger context and how disruptive and disturbing this can be for acquaintances, and young acquaintances in particular, of these potential perpetrators, innocent until proven guilty. And then this one is kind of special. I regret to report Louisiana State University, a professor in what they call their Ag Center, who was arrested not only for child pornography, but also for having sex with animals and possession of marijuana. So not a great combination. If he's convicted or pleads guilty, I suspect he will face quite a long term, but you never know. Years ago, when there was litigation, the first round of litigation involving discrimination against female professors in higher education, there was some important work done on the affinity that a male judge, highly educated, usually a little older, would feel with a male professor, highly educated, who was a defendant in a civil trial involving sex discrimination. And so, one hopes our judges are not biased, but there was research suggesting in the early days of Title VII, the major sex discrimination statute, that judges were giving a lot of benefit of the doubt to certain people with whom they had a cultural affinity. And that may be true also in some of these lighter sentences that we saw at the beginning of these judicial developments. And then, unfortunately, this year, I think for the first time I've been doing this, I found more examples of people in higher education who've been accused of abusing members of their own family, their own children, or in their more extended family. Whether this is a product of COVID, I can't say. I can't really generalize from a handful of cases. It's not too surprising, first of all, because of COVID, and second of all, because most child abuse is committed in the family or within the community, far more so than in camps or daycare settings. So that's statistically simply the way it is. Our world in higher education has a lower incidence of child abuse. So these sex crimes within the family are something to be expected, but I've just seen more of them this year. And I just have to say, I really know how to keep a room very quiet and very attentive to what I'm saying. At the outset, perhaps I should have acknowledged and honored the terrible nature of these crimes, both of pornography and even more so of the direct sexual abuse of children. They have deep impacts on survivors and on the community, on the families, and so it's really heavy stuff. So here we have a couple of examples. East Carolina University, an accounting professor and his wife were accused of abusing their own children, withholding food from them and neglecting them. And I believe this was a situation where the elementary school teacher brought the charges to the attention of state authorities. And so they've been arrested for those crimes. In North Carolina, unfortunately, this one is just horrific, as they all are. A professor of computer science, and it's hard to hire a computer scientist these days, And he had a 6-month-old adopted son who died of cardiac arrest, and he's been charged with the murder of the child. And then we have two from Purdue. I believe we may have some virtual attendees from Purdue, even though it's just down the street. They have that issue of the conferences in my home city, and I have work to do. Many of us have faced that kind of pressure, so I'm just guessing our Purdue colleagues may be in that situation. We have a computer science professor whose adult daughters have accused him of molestation that began when they were in the 3rd grade. And that led to criminal charges against Professor Given. And then also at Purdue, coincidentally, an education professor. The news reports on this one are kind of wild. He reportedly, and these are only reports, locked his 10-year-old son in a crate. I can only guess it was a crate for a large dog. That was never specified. Broke a chair leg and beat his wife within sight of the child. And took away her cell phone so that she couldn't report it, and eventually she did, and he's been arrested for that on the basis of those allegations. And then this one was last week. I'm very current. A professor from the University of Kentucky who is chair of the communications department was arrested for incest with a victim under the age of 12. And the age of the victim under state laws can be relevant to the severity of the charges. So if you have a victim who's under 12 or under 10, that crime that charge is more severe than an older victim who's still a minor. So the media reports don't suggest whether this was a child of his or a niece or nephew, that kind of thing. The nature of the familial relationship wasn't disclosed. But this, if you look at and I hope you all do look at the HepNet monthly newsletter, the HepNet happenings, down on the bottom right, you can find news reports. You click through to a series of news reports on what has been happening particularly in terms of arrests and sentencing, guilty pleas and so forth in the higher education world, and then some collateral cases that are also of potential interest by way of analogy. So look in the HepNet happenings, and I'm guessing Professor Reed will be in next month's HepNet newsletter along with our Professor Kimberly Sonnenstein, if I've remembered her name correctly. Yesterday's guilty plea. Now, also this year, we have an exoneration. And this situation is really quite interesting. William Arnold was employed with the Tennessee Board of Regents. He was the system-wide director of diversity, equity, inclusion, serving in that role. He also volunteered as a big brother. He had had about 20 mentees over the course of his career and time with Big Brothers, Big Sisters. A mother accused him of abusing her son, who was maybe 10 or 12, something in that realm. He was convicted by a Tennessee jury and sentenced to 25 years. The day he was convicted, he gave his watch and a ring to his dad, who was in the courtroom, and said, "We're going to get this all cleared up." Well, it took 7 years for it to get all cleared up. It turned out that the mother's boyfriend had a younger brother, a 17-year-old brother, who was also named William. And the child had accused William of abuse. Now, William Arnold said, among many other things, that's highly unlikely. This child either called me Dr. Arnold or Mr. Arnold throughout our relationship. The 17-year-old eventually confessed in a videotaped interview that he was the perpetrator. Nonetheless, William Arnold spent 7 years in prison before being exonerated. So it's a tragic story in several respects, and I'm hopeful that he is getting his life back together. And I think the exoneration was actually last year. I just learned about it this year, so it's a little bit old news, but I think it's such important news as well. So that covers our criminal cases, and now we're on to our civil cases. So the headlines reported earlier this year that 90 women are suing the FBI for totally bungling its investigation of Larry Nassar. As I recall, the allegations include that one of the FBI agents was trying to get a job with USA Gymnastics at the time, and there was quite a condemning report of internal government report of the bad work by the FBI on this case. The Justice Department declined to prosecute any of the FBI agents who were involved, but as I say, 90 women have brought a civil suit against the FBI, and that's a pretty tall hill to climb because there are certain government immunities. But when the government itself has admitted misconduct by its own agents, I think you're a little farther ahead in that lawsuit. It wouldn't surprise me if that case is eventually settled, but it was just filed this past year. And then we also have a civil lawsuit by under initials, I think it's IR, or no, that one may be coming up, against Rice University and Professor Darius Paulus. He taught piano. He was a professor of piano, and guess what? He also taught private piano lessons in his campus studio. Any of you have that going on? Yes, yes. Many hands go up there. And so this survivor alleges, a piano student alleges that the abuse began when she was 10. And there's also an allegation that the university had ignored earlier complaints against the same professor. So you can see how the university can get drawn into a civil suit by a survivor, quite understandably, I think. It's a logical thing to sue both the perpetrator and the perpetrator's employer. And then this one is quite interesting from a technical legal standpoint. You can sip your coffee or check your cell phone or something if you'd like. Thomas Andratis was a hockey coach at the University of Minnesota, as you can see, from 1984 to 1985. So that's a very long time ago. And there is a civil suit by survivors of alleged abuse by him, both on claims of abuse because of a very long statute of limitations for child abuse claims, and also claims that the University of Minnesota failed to notify subsequent employers of this hockey coach. Now, those of you who are hockey fans may be aware that there is sort of new information coming out about sexual abuse, not necessarily child abuse, but sexual abuse by some big name hockey stars, and then youth sexual abuse in youth hockey leagues. So this may be of a piece with that broader context. It's sort of like a religious organization coming to grips with its own past. Here we have a sport that that many people are saying has had a history of abuse of women and also children. So if you accuse a school of not being forthcoming in employment references, those subsequent victims are sometimes termed downstream plaintiffs. So these are not plaintiffs who were alleging that while this coach was employed by the University of Minnesota, they suffered abuse, but rather the university made negligent references to subsequent employers. The Citadel in South Carolina faced a lawsuit over many years brought by a lot of downstream plaintiffs, as well as one or two plaintiffs who allegedly or perhaps actually suffered abuse at the Citadel. So these long statutes of limitations and these efforts to link back through negligent references are an infrequent but recurring phenomenon. So in this case, the lawsuit included a claim under Title IX, which applies, of course, to the university because it receives federal funds. And so the Title IX doesn't have a statute of limitations in it. You borrow a statute of limitations from the state where the discrimination on the basis of gender occurred. So the court here addressed the question of what is the right statute of limitations from Minnesota to borrow into a Title IX case, a federal Title IX case. And the plaintiff tried to say what you borrow is the Child Abuse Victims Act, because as most of you have encountered in the past, those tend to be much longer statutes of limitations. And so the plaintiff was saying, under Title IX, that's the one that you borrow and bring into my Title IX case. The court, however, said, nope, I'm not doing that. What we're going to borrow is the much shorter statute for personal injury. And so if I in Minnesota, trip on a step and claim negligence, and I'm injured by somebody's negligence, the statute of limitations might be a handful of years rather than a decade or more. So here we have a federal court saying the one statute of limitations to borrow is the general personal injury statute, which is much shorter than the Title IX, much shorter than the Child Abuse state statute of limitations. So interesting to geeks, relevant if you're in general counsels find yourselves in this situation, but it's not it's an acquired taste. I think what statute of limitations apply legal issues. So I'd also like, as I end my judicial development section, I'd like to alert you to a very interesting development. The FBI sought a search warrant for, I believe it was a laptop, it might have been a cell phone, that was using an end-to-end encrypted app. And they had reason to think that the owner of this device was viewing child pornography. But the device was locked with biometrics, with facial recognition. And so I think this is a first. I'm not a criminal lawyer, but I believe it is if not the first, an early time when a judge said, yes, you, the FBI, can require the subject to unlock the electronic device with facial recognition. The same would hold true for fingerprint recognition. And so this occurred, the device was unlocked. I don't know what has happened subsequently. I did read in the tech and a high-tech kind of article, if you really want to preserve your end-to-end encryption, don't use biometrics, don't use your fingerprint or your face, use some really horrible password that nobody's going to figure out. Now, on this slide, you'll also see the name Wicker, I think it's C-K, yes, W-I-C-K-R. And that is a platform that reportedly is increasingly being used by people who want to view child porn or solicit sex from children because of its end-to-end encryption. Congress is looking at regulating high tech, and we'll talk about that some more in the future. But just know that Wicker is a platform where perps and potential perps may be lurking. So that leads me to legislative developments and also some more into high tech. Yes, on July 30th, the Senate Committee on Commerce, Science, and Technology reported out 2 bills on children's online privacy. The first would amend the COPPA, C-O-P-P-A, the Children's Online Privacy Protection Act, and some of you may have encountered that. It requires websites that are targeted to age 13 and under to take certain steps for parental approval or approving the age, and it's largely, and it applies, I believe, to for-profit entities, but I might be wrong about that, so let me strike my previous comment. But COPPA has applied to 13 and under, and universities typically do not target their camp websites directly to that population. One of the proposed amendments to the law, however, would raise the age from 13 to 17. Now, tell me that your websites aren't targeted to 17-year-olds. I mean, those are your prospective students as well as your campers and other people. So, and then there's a second bill that was reported out from the Senate Commerce Committee that targets big tech and would protect kids and hold big tech more accountable for this. However, the Speaker of the House, Nancy Pelosi, is not in favor of these 2 bills because she's looking for a bigger online privacy protection solution, not one just targeting kids in these narrow ways. And I really shouldn't have stood up here without checking whether the Child Online Privacy Protection Act covers nonprofits, because that is the element that would be most relevant to most everybody in the room. So I will follow up on that and put it on the discussion board. So it's questionable whether either of these bills will move forward. It's because of Nancy Pelosi's concerns in the House, and because we're about to face the midterm elections, and Congress isn't going to be doing much in the next few months anyway. But just this is an awareness kind of thing. And then we have another bill in California. So as I mentioned earlier, I'm covering federal developments and state developments. California has passed something that does a lot of what the 2 federal proposals would do. It's called the Age Appropriate Design Code Act, passed 2 weeks ago on the 30th of August. it's not clear whether Governor Gavin Newsom is going to sign this bill. So again, this is just situational awareness. It would protect, it would constrain in certain ways websites and vendors that are targeting people under the age of 18, and has some provisions for standardizing age verification, because it's my understanding that the under COPPA, the Federal Privacy Protection for Kids, you can put in that you're 25 years old even if you're only 9, and if you know to do that, then you have an open access into material. So California is moving forward, and we'll see whether this bill gets to the finish line or not. Now, another kind of legislative development is expansion of the statutes of limitations for child pornography and child abuse. And this has been going on for quite a while. Jerry Sandusky's crimes came to light 11 years ago, and since then we've seen a number of states either create a one-time window, a look-back period that expires, or simply lengthening the time period in which criminal charges or a civil suit may be brought. Child USA is a group in Philadelphia headed by a professor at the University of Pennsylvania, and they have a very good state law tracker, and they mention that these 4 states on the slide have in various ways expanded their either civil or criminal statutes of limitations. So if you're in one of those states, go have a look at childusa.org 2022 SOL, standing for Statute of Limitations. And you'll see there are also some bills pending in other states, but these are states with laws that became effective in 2022. So, again, just in the general area of youth protection, not specific to higher education, another federal development is that 2 senators, Patty Murray from the state of Washington and Ron Wyden from Wyoming, have become concerned about the abuse of children in private residential facilities, and these might be psychiatric hospitals, and they're for-profit entities where children may be detained or housed, and there have been reports of abuse in such facilities. So they are seeking information about that, and whenever a senator writes a letter seeking information, the press release comes out too, and so this has attracted some press attention. I haven't seen news of any developments concerning it. They may hold hearings at some point. I'm not sure what committee this would come out of, but it's of interest, I think, also in connection with the whole Canadian tragedy of residential schools there. How are we doing in the U.S.? And I think there are some issues that have yet to be addressed in that realm in this country. All right, I am coming close to the end, but there are some important executive agency developments, and the ones I have are both in the federal realm. The Department of Education, as you might have seen, I think it was in June, came out with proposed regulations amending Title IX. Let me digress and just give you a primer on the federal regulatory process. The laws may require an agency to adopt regulations, and when that happens, the agency begins to work. Sometimes it's very slow, sometimes it's faster. And the first thing the agency does when they have something ready is they publish what's called a proposed regulation. It's proposed for public comment. Usually I think there has to be at least 60 days for the public to weigh in on whether a regulation is good or bad. If it's a regulation about oil well drilling, the oil well drilling industry, floods the agency with comments. And with respect to Title IX, we are getting a flip-flop between the Republican administration and the Democratic administration. We had not had any regulations from the Department of, or any substantive regulations on sexual assault from the Department of Education until the prior president's administration, and now the current administration, the Department of Education, is seeking to make some rather significant changes. It got some press coverage at the beginning of the summer. I believe the comment period for public submission of comments is over in about 10 days. The groups that represent survivors and the groups that represent alleged perpetrators and the higher ed groups are all submitting comments. There'll be thousands of comments, I'm sure, on these regulations. The department then has to read through them all, respond, and publish a final rule with explanations of why they accepted or didn't accept the proposals made in the comments. So interestingly, to my mind, the proposed Title IX regulations have a much sharper distinction between primary and secondary schools and what the Department of Education calls post-secondary education. So primary and secondary schools are supposed to do things one way with somewhat more streamlined procedures, and higher education has somewhat more elaborate procedures. Now, youth programs in higher education are sort of in that gray middle ground, and so that will be a matter of interpretation, how the department interprets these regulations, assuming that sharp divide survives into the final regulations when they're published, probably later this year. Or it may be that they will appreciate that the line is not as sharp as the one they've drawn in their proposed regulations. So there'll be a lot of press coverage when the final regulations come out, and your Title IX people may already be redoing their processes or planning for new regulations. They ramped up their processes to comply with the prior administration's final regulations, and now they're anticipating final regulations again. So be kind to your Title IX coordinators, because they've been under a lot of stress for a few years. Not that you haven't as well, and perhaps some of you are in Title IX offices, in fact. And then the other federal development has to do with something called the Child Protection Improvements Act. This act was signed by the prior president, I believe in 2018, and does something really quite remarkable with respect to access to FBI fingerprint background checks. The way the world works today, or up until we have new regulations, is that each state can decide whether they want to make the FBI database available to entities within the state. And some states say yes, and some states say no. The Child Protection Improvements Act makes the FBI background check database available to all states and available to nonprofit youth-serving organizations and educational institutions for very reasonable fees. It's essentially for the cost of the background check. So we've been drumming our fingers and wondering, when is the FBI going to get its act together to issue some regulations? Now, I mentioned that there's a process for the issuance of regulations in the federal government, and I didn't mention that the prelude to that process, sort of the overture, is that twice a year each agency has to say what regulations they're working on and when they think they'll be coming out. So I check from time to time. I couldn't quite figure out who to contact to figure out when the FBI would be issuing regulations. But lo and behold, to quote the Latin, mirabile dictu, I say it's a miracle. On June the 30th, the regulatory calendar came out, and the FBI said that by October or November, and it's not a hard date, they were planning to issue proposed regulations under the Child Protection Improvements Act. And we now have the name of somebody who is writing these regulations. So the American Camp Association is getting excited about this, and all the groups that lobbied originally for the Child Protection Improvements Act are becoming activated to take a look, to make some liaison with the FBI to see what they're thinking in the proposed regulations, and then to most likely submit comments once the proposed regulations come out. So it may be that by the fall we'll have proposed regulations under the Child Protection Improvements Act, which could significantly lower the cost of background checks for everybody in this room. So we're going to watch this very closely now that we have some, contact information and some approximate calendar. So that is the most exciting executive agency development that I've seen and that has excited me in a long time. So that brings me to the end of this year's really just a whirlwind of judicial or cultural developments in child abuse and child protection, judicial developments, sentencing, arrests, abuse within the family by perpetrators associated with higher education institutions, legislative developments, particularly in the high-tech area where there's a lot that's bubbling, and state by state in statutes of limitations, and then finally in these executive agency developments on the federal front. So I've taken you through this is the Cook's tour of the year. And I was as up to date as yesterday, but I don't know what's been happening today. There could be new developments, but we'll keep on top of it. We'll put things in the HepNet Happenings newsletter, and I'll be happy to try to answer any questions you may have. I don't have details on the whole swath of material that I've covered, but if you have either general questions or specific questions about anything I've discussed, bring it on.
Actually, I have a question that was posted in the virtual room.
Mm-hmm. No, I think you're not on yet. Maybe let me turn this off just for a second.
Actually, I'll just ask it if you can repeat it in the mic and the thing here. Megan was asking about the use of the term child porn. She said, my understanding is that the term porn is something which people consent to versus the term child sex abuse materials, which names these materials as evidence of abuse. Is child porn a legal term?
That's a very good observation, and it's one I can't answer. In the adult porn industry, of course, there is consent. Oh, forgive me, absolutely. The question was whether child porn is a legal term or whether it's child exploitative sexual material or some wording to that effect. And that may be a very good distinction that I'm learning at this moment. And it may be that in the adult porn industry, there is an implicit or explicit understanding of consent. With child sexual abuse material, there can't be consent. These are children. They're not able to consent. So it's exploitative sexual material, which I am using the shorthand child porn for, with the added footnote that obviously there is not consent. And interestingly, in that realm of child exploitative visual material, cartoons are okay. What's not okay is actual images of children who are under the age of consent. And so there's sort of there's a lot of criminal law in that area that is I have a tablespoonful of knowledge about, and I appreciate the comment from implied in the question from our virtual listener. I also talk about perps sometimes, and that's not a legal term. And we have a question here, which I'll gladly repeat. All right, so this was a very helpful comment from the website of the Federal Trade Commission, which has enforcement authority under the Child Online Privacy Prevention Act, where the description from the FTC website speaks initially to for-profit operators of websites, and then goes on to cover other categories, but it's not. I would have to look at the statute to understand whether that for-profit qualifier carries through the whole statute or is one type, with nonprofits being other types. And I would say that your coaches' LLCs may be deemed for-profit enterprises unless they have a tax exemption. And so I appreciate the explanation, and we'll look further. I now recall having grappled with this question before a few years ago, and I don't remember where I ended up with it, but the reference on the FTC website to for-profit operators is a very good clue that nonprofits may be exempt from COPPA, and we'll see whether these legislative proposals to expand COPPA might reach into the nonprofit sector if COPPA as it exists today does not. Was that clear as mud, or Pranisha? Yeah.
I just wanted to say that I was really grateful that you brought up all the individual encounters that were happening with individual faculty. Are you seeing with your consulting an increase of universities taking initiative with including one-on-one interactions like private lessons and coaches and things like that into their youth protection policies now? Because at one point we were put in this box of only doing camps and programs, but now are we seeing this push that our universities should collect and basically put youth protection around these individual encounters and other encounters as well?
Yes, thank you. And the question was whether we have seen, and I'd make this the collective we, more institutions putting restrictions or protections into one-on-one interactions, not just groups like camps, but one-on-one interaction within a camp or a music lesson or a counseling session. Let me just ask for a show of hands, and I'll report out what I find. Does your institution's policy put some constraints on one-on-one interactions? Does it address one-on-one interactions? Oh, I'd say that's 95% of people in the room. So I think that helps answer the question that was posed. Did you have a follow-up? No. Okay. Because I play the cello, and I've been particularly interested in youth protection in the context of music. And last year or the year before, we had a panel at the HEPNET conference. I believe it was a virtual panel on music education with a Baldwin Wallace professor and a professor from Ohio State, both of whom had great sensitivity and great ideas about youth protection. You don't call them private lessons, for example, you call them individual lessons. And they should be, interruptible, observable, those kinds of factors approved in advance. I also, some years back, worked with a conservatory that teaches music and ballet, and we worked a lot on the use of touch in education of youngsters. And at one point, the British Music Teachers Association forbade music teachers from touching their students at all. And the teachers rebelled against this, and the total prohibition was withdrawn. There can be ways to have appropriate touch. You advise the parents in writing how touch is used. You advise the student as well before lessons even begin. You ask permission of the student. I'd like to fix your bow arm now. May I touch your right hand? If it is effective, you can touch with a pencil instead of with your own finger. And then you don't let anybody cover up the side light windows by the door into the music studio. I know one community college that installed windows in its music practice rooms and music studios for faculty. Same thing occurs in ballet, athletic training, massage. These can be observable, they can be interruptible. The head of the music department can make clear to everybody that I might just be dropping in on lessons. Don't be surprised if I poke my head through the door. So there are steps that are helpful in regulating those one-on-one interactions. Yes, Pranisha. Right, right. And let me just repeat those for people on the other side of the room and our virtual colleagues, that it's if faculty, take the example of music faculty, are teaching private lessons, is it through their own LLC? Are they using university resources? Do they have insurance? What are they doing in these areas? And let's see. Oh, this is a really tricky legal thing. If you're in a public university building that was built with bond funds, there can be a prohibition on using those facilities for profit-making activities. So if you're at a public institution, and even private ones may use bond funding, look at the bond covenants, which may prohibit those for-profit activities from occurring within the facilities. Other questions? And I see, yes, another online one. Good.
Yay, I'm going to try this again. Okay. Yes, we have one more from Courtney. She says, I'm noticing increased interest in dual enrollment programs for high school students, including at my institution. These youth are in a gray area, minors and college students. Are you seeing any legal trends or cases to help navigate this?
It is huge. I can tell you that. There's one community college in Florida that's building a dorm for dual enrollment students. I know another institution where dual enrollment students live in a dorm but take classes from their own teachers off-site of the university campus. This is something I do want to probe further. There are some answers under FERPA, what FERPA rules apply, institutions that exempt enrolled minors from their youth protection policies would likely exempt the dual enrollment students just by virtue of the wording of their policies. There's an association of dual enrollment educators, and I want to embed with them or infiltrate them to see if there are some good resources or collaboration between K through 12, higher ed in the dual enrollment space. It is more complicated legally than the charter school that a university may run or the partnership a university may have with an elementary school for tutoring or the charter school that a university may run. So child abuse is child abuse, and there's a good question of what you want to do, what the reporting mechanisms are, what you want to do about it. And I see a hand up. I'll call a couple hand up. I'll call on you in 1 second. Let's see. When your policy exempts enrolled minors, it doesn't exempt them for all purposes because you are still under a state obligation for the mandatory reporting of child abuse. So don't think that the sexual activities of a 17-year-old with a professor are okay. You may have a mandatory duty to report that. And that would also apply to the dual enrollment context. It's not exempt. And we had was this a follow-up comment on dual enrollment?
Yeah, I think you just said what I was going to say. Is I think a lot of times we've got to be really clear in our policies because we hear exemption and people think that the policies don't apply. And I think exemption from what? Is it from registration? Is it from training and background checks? Is it from reporting? And like you said, it's never from reporting ever, but it might be from registration, but then thinking thoughtfully about, if all of your faculty are background checked, then that may be a box, even though they're not registered. So just being really clear about that, because exemption doesn't mean non-reporting. So.
Yes, thank you. That's a really good reinforcement and a much more eloquent a statement of what I was trying to say, too. I think we have another comment back here.
Back here or here?
Yeah, you, sir.
Man with the mic. Okay. Question on dual enrollment, and I'm fairly new to this piece. Most of our dual enrollment is agreements with K through 12 districts who are they're teaching our material. They may be officially, the teachers may be officially our teachers, but they're teaching there and they're doing it under their policies. Is that all falling to the K-12 or does it translate to us? And I understand there's now one where the school district is actually busing their kids to one of our campuses and doing it on our campus. Does that change it?
Yes, it could. And one key piece is when you have agreements with these other institutions for dual enrollment, to make clear whose policies apply and who's going to do what. I think anybody should report, or anybody who's a mandatory reporter, or anybody who's a required reporter under your policy. And I'm active in the National Association of College and University Attorneys, and I was on a panel where another panelist submitted some form agreements for these dual enrollment programs, and perhaps that's something that HEPNET may want to get into as well. I think it's a topic I've been thinking about quite a bit. I don't have a lot of answers on. It's sort of like there are a lot of pieces. Just as I was saying, the Department of Education is drawing this clear line between K through 12 and higher ed, and it really is not such a clear line. So not only will we have Title IX problems, but we have youth protection issues that arise as well in that messy, what is now currently messy gray space between them.
I would also say, too, that if you're working on your dual enrollment policy, to address whether or not student orgs can allow those same dual enrolled students to take part in those activities, and what is your obligation to disclose to those organizations that they're minors, especially with FERPA, and what is your obligation to make sure they're screened and vetted, because now they're working with children. So, and the student orgs, of course, are underinsured and a lot of times not covered by your insurance. So do you really want to take that risk?
Right, and just to end on one of these nerdy kind of notes, and I am ending. I'm getting the sign of, the hook is coming. There's another federal law like Title IX that applies if you receive federal funds, and it's called the Age Discrimination Act. And the Supreme Court recently forgot to include the Age Discrimination Act in a list of these add-ons to receipt of federal funding. I've been meaning to write to the clerk of the Supreme Court saying, and there's the Age Discrimination in Employment Act that covers people age 40 and older. The Age Discrimination Act, and your general counsels are very unlikely to know this unless you're at UConn, because they got nailed. It doesn't have a lower age limit. And so if you say a 15-year-old can participate in this program, but a 14-year-old cannot, you need to have a very strong justification for that sharp line that you're drawing. You're not looking at maturity or intellectual capacity or other things. So what might be considered arbitrary age distinctions could be challenged under the Age Discrimination Act, not the ADEA, Employment Act, the ADA, which is not the Americans with Disabilities Act. So it's a great big soup, and age distinctions between the dual enrolled students. We don't want any 15-year-olds, dual enrolled students going out with our rock climbing club. You have to really think through why you are creating that distinction. So with that kind of soupy, techno-geeky kind of thing, I'd like to thank you very much for your attention, and I look forward to the next few days together.